I want to bring in our guest for this hour, trial attorney Michael Jaafar. Michael, tell me, I mean, you know, these calls in and of themselves don't seem very significant to me. Talking with his ex-girlfriend, Kathy, about money and spending money, and then talking to his mom about, I need to see you sooner, and reward money that they don't want to, or they don't say, get the reward money, solve the case. What does all this mean to you? It's very confusing.
I fully agree with you, Judge Ashley. I was looking for a smoking gun, and before the calls were played, I thought to myself, there's no way that this dentist would be dumb enough to be on the phone talking about a murder. There's just no way, and that ended up being true. He did not do it. He didn't even insinuate it. His demeanor in the courtroom when he was listening to these calls, you know, rolling his eyes, shrugging, I didn't like that too much, but I agree with you. These are not significant. The state has a massive burden to prove. They have to prove that this dentist arranged and orchestrated and paid for the murder of a law professor, his brother-in-law, in the midst of a case. It's a massive burden. So these phone calls did not do it for me.
And it does connect all the people, right? Like, we know the two shooters as well as the ex-girlfriend McBanawa are all serving time in jail for this particular crime. But on the other hand, it's not enough, I think, to show a relationship between them all in texts and calls back and forth. I don't think the state is there yet. One other question I have to ask you, though, and that is when we're talking about the defendant. Some people have said, oh, he's crazy like a fox. So he's purposely saying things to steer them away or make everybody think he doesn't know anything about it. And maybe he knew he was being listened to. What are your thoughts about that theory?
I think it's a very legitimate theory, right? Because it was the minute that his brother-in-law died by being shot in his driveway, the day before a contentious trial with his sister, the minute that happened, you're going to sit up and you're going to think, oh, wow, the finger is going to be pointed at least at somebody in my family, and you're going to be cagey, right? So, yeah, he was very cagey. Whether or not he did it, he's going to be cagey, right? So, like, he either did this or he didn't do it. He either orchestrated it or he didn't. Either way, in either scenario, he's going to be cagey and he's going to be careful. He's definitely not going to joke about it. He's definitely not going to say, thank God that happened. He's going to say the right things, and he's going to know that unless it's in my mind, the minute it leaves my mind, whether it's in person, whether it's in an elevator, whether it's over the phone, somebody could hear it and misconstrue it, and I spend the rest of my life in prison. So I agree with you, Judge Ashley. That's a good theory.
And I didn't mean to interrupt you, but when you said cagey, all I could think was, wow, I think that kind of describes some of his demeanor in the courtroom, because there's been a lot of fodder about what is he doing, and he's reacting and he's smirking, but at times, maybe it's cagey that I'm witnessing. I'm trying to put my finger on it. All right, stay with us. Still with us to discuss as well is trial attorney Michael Jaafar. Michael, tell me this. I'm surprised, even though there's a presumption of innocence, you can choose to go to trial with the evidence as Chanley described in this opening statement by the prosecution. I'm a little surprised there's been no deal.
You know, it didn't dawn on me until you brought it up, but the only way that there's no deal here is because no deal was probably offered. Because, I mean, we're in the era of people using cell phone data against defendants. And if somebody does something in a heat of passion, right, that means they didn't prepare, they didn't plan, they kept their cell phone on them, they had their watch on them, and their watch was this is a cyclist and a yoga person, and so a person who is tracking her calories, who's always connected to her cell phone and her fitness watches. And so if she did it, she did it in a heat of passion. In a heat of passion, you're not going to disconnect yourself from the technology and the electronics that track your every move. And so I agree with you. She's cooked. All the evidence is pointing towards her. So the fact that there's no deal, I could only assume no deal was offered, and so the defense has no chance but to throw a Hail Mary, because it's malpractice to not try a case when the offer on the table is plea is charged, go to jail for the rest of your life. It's malpractice to not try that case and to not throw a Hail Mary. God knows, as a public defender, I've been forced to do that. So I do not envy her attorneys. I'm really interested to see what legitimate defense they have. Probably none, but I'm looking to see that.
But it was zealous. So the opening statement of the defense, and again, Chanley just shared with us the objections being made by the state during that. We know trial skills wise, you don't object during the opening statement or closing argument because it could be a bad look for the jury unless you really have grounds that you need to protect and you need to stand up and object. And part of what he was trying to say was to the jury, you had your chance. You could have gotten out of this on Monday. The objection was sustained. What's your position about addressing what the jurors could or couldn't have done, or the fact they're serving on the jury? Should that be allowed during opening, in your opinion?
I think when you're in a Hail Mary situation, you have to throw everything you can at the fence. It's very, very, very out of what's the word? It's very subpar if you're an attorney and you have to object to an opening statement or a closing statement. It rarely happens, but we see it happen all the time in situations where you're either desperate. We saw it in the eye drops murder case, right, where the prosecution objected to the opening statement of the defense attorney who said it's impossible to die from Visine, right? And it's not possible. They had to object, right? And so we see it happening. And so in this situation, when they were objecting to these statements, I think they had no choice but to inform the jurors, hey, listen, you know what? We're probably going to lose this case, but we want you to know that you shouldn't have done X, Y, Z. So I do think they had to do it just because of the overwhelming evidence against their client.
And they took that chance. All right, stay with us, Michael. We're going to take a break, but when we come back, we, of course, will pivot back to the dentist mastermind murder trial as the jury is getting ready to hear one of the clearest calls yet. We'll bring that to you. Stay tuned.